Welcome to Estate Planning Weekly. I'm your host, Bill Gross, at Bill Gross Probate on social media. And I'm really excited to have here today a lady who helps people begin their legacies through estate planning, Florida attorney Alecia Daniel. Alecia, thank you for coming back to our program.
Thank you for having me again.
Now, we've had you on Probate Weekly, which is when things go wrong, how we can minimize the pain, how we can clean up the mess. I kind of feel like it's how to clean up the mess in your kitchen after Bill was cooking. But estate planning, I think, is designed to avoid that happening by planning ahead of time. So let's talk about what are one of the two things that you see their problems that people can avoid with a proper estate plan.
The biggest thing that I see that people can avoid is not having a plan, right? So if you don't have a plan, 9 times out of 10, you're going to end up in probate. And as you mentioned, there are ways to avoid it. It just requires having a plan. And there are a few different mechanisms that can be applied to make sure that you are avoiding probate.
Now, I do my business primarily in California. You're a Florida attorney, so we're not getting legal advice here, but we're getting business advice in the form of a podcast. But I maintain, not legally, but business-wise, in California, because we're so litigious, that 90% of people are better off with a bad plan than with no plan. When I say bad plan, I mean just a templated online quickie, nothing personalized, but something is done. But if you own a house or have kids, I maintain 90% of any of that is better than nothing, because the problems of having nothing can be ugly.
Right. But I've also seen when people have those bad plans,
Okay.
especially when you're talking about the Florida homestead. Really bad language can lead to really bad results. So if you have the wrong language, for example, in your will with respect to your homestead, that can be the difference between that property being treated as a protected asset where we don't have to worry about most creditors, or now it's going to be money for all of your creditors. And that's the biggest. So, having a plan, yeah, for some things it's better than nothing,
Okay.
but you can really, really make huge, huge mistakes by trying to do it yourself with a bad plan.
And you can make mistakes in California. The homestead is a unique feature in Florida, and that's one reason why many people move to Florida to retire, because you can set up no income tax as well as set up a more favorable plan. So talk about the homestead. What kind of advantages does having a proper homestead exemption provide for an estate?
So the number one benefit is, as long as that property is being transferred to your family members, so legal heirs, legal beneficiaries, it's going to transfer without having to worry about certain creditor claims. And that's pretty much, taxes have to be paid. We're never going to get away not paying our taxes, right? So property taxes. And there's a mortgage. If there's a mortgage on the property, that has to be paid by, whoever's going to take that property, they're taking it with that mortgage on it. And then, of course, we have mechanics liens. I always use the example of the roofer. You don't pay them, they're going to have a lien against that property. But all of your other creditors, if that is someone's bona fide homestead, we do not have to worry about selling the homestead in order to pay those creditors. There are other benefits. You have a tax reduction on the property tax every year. But when you're talking about estates, the real benefit is that creditor protection that we get with our homestead.
So you might need to sell for other reasons, i.e. you need money to pay for living expenses, or maybe you need money to pay medical expenses, not bills on creditors, but going forward expenses or whatever it might be,
Right.
or buying a new property. But you don't have to sell because creditors can't force you to sell the property if your plans to stay there.
Correct. Right.
Now talk a bit about, because part of the lack of planning is not being able to access assets efficiently and in a timely manner. The one that I deal with the most is obviously the real estate, where it's great that creditors can't get the equity, but what if they need the equity for various purposes, maybe before passing, while they have medical issues, wanting equity for medical expenses, or maybe moving to new property. Talk a little bit about some of the methods. For example, do you work with reverse mortgages as a way to kind of keep the equity there protected, or pre-plan, or what are some of the ways that you can help people plan ahead so they have the resources, not just don't lose them to creditors?
Well, so I don't handle mortgages at all, right? So I don't work with reverse mortgages. My world with reverse mortgages, I am very familiar with what they are, how they work, and I deal with them quite often in probate, because a lot of times people do need to tap into that equity that they've built up in their property just to survive, especially people that are on fixed income. So I see it all the time in the probate world. The key thing that I always tell the clients when people do reach out to me and say, hey, I'm thinking about it, I just tell them, I really ask that they communicate with the children, because the biggest issue I see on the probate side is where the children had no idea that mom or dad even took out a reverse mortgage on the property. And the first time they find out about it is after mom has passed away and they get the foreclosure paperwork. That doesn't really give them much time to plan and prepare. And often you could very well have a situation where the children are able to help mom or dad with some of those bills. They might be able to, plan around the issues that mom or dad are having without having to tap into that equity. So in estate planning across the board, I always say communication is extremely important. And it can really, really help reduce issues down the line.
Communication is, one of my mentors used to say, communication is the hallmark of any successful organization, and family can be an organization. But part of the problem why people have to turn to estate planning is they have dysfunctional communication in their families. So, and I think sometimes they feel like the paperwork is going to solve that problem, but it just seems to me the paperwork becomes the new paradigm for the battle between the dysfunctional family members. So talk a little bit about maybe what are some of the common mistakes made, and what can you do to help people minimize? You can't eliminate, but what can you do to help minimize some of those challenges?
So, look, at the end of the day, you can't control who is going to do what, right? When you have a plan, at least you are putting out your wishes. That's the only way to make sure that someone is aware of your wishes, is to put them down in writing. As far as, biggest mistakes I see, it's really that communication. I mean, a lot of times it's the shock value of mom didn't leave me what I thought, or I thought I was getting this, right? And so that's why I always go back to communication. That is, to me, the number one mistake. In some families, communication is not actually possible. We know that. And so you definitely want to make sure, if you are disinheriting someone in Florida, you absolutely want to make it clear that you are disinheriting that person. It needs to be in the document, in your will, in your trust. I always say, don't give someone $1, don't give them $10 because you want to kind of stick it to them and let them know that this is all you think they're worth. The problem with doing that is, if we have to go to probate with that will, now because you've named them as someone who's receiving $1, we now have to include them in the probate case.
The beneficiaries, not just...
They're a beneficiary. And in Florida, you have to provide them with notice because they're a beneficiary. If you just say, I disinherit this person, you don't have to worry about that, as long as we have the original will. Whole other thing if we don't have the original, because certain people are required to notice. But that's one mistake that we can really avoid, creating issues in a probate case by simply trying to make someone know you really, really are mad at them by leaving them $1. That's actually more of a problem than leaving them nothing.
Well, I think whether you're past or you're alive, sticking it to people just really is not generally the best game plan. And I know that's one of the reasons why I'm married. My wife will say, you sure you want to do that? No, not really. Or just having to think about explaining that to my wife. Why did I do that? Because I was mad. Yeah, probably just not really worth all the trouble and heartache. So now, do you play that role? Do you sometimes have to play traffic cop with customers? And you obviously can't, countermand their desires, but at some point, do you provide them a sounding board to say, it feels good today, but here's what you might be setting your family up for?
Yeah, I do. I have to be that person in the room because, a lot of people were guided by emotions, we're guided by family history. We have to cut through all of that. And sometimes you do need someone who's non-biased, who's not connected to any of it, to help you kind of see through. It's almost like mediators,
Right.
And I also have to serve in that role when it comes to naming your agents. So, for example, who's going to make your medical decisions, who's going to make your financial decisions. I recently had a situation where, my client wanted to name a particular child as her agent under her power of attorney. I know the family dynamics, and I know that that particular child has actually stolen from her in the past. And so we had to have that conversation. Is this really the person that you want to be in charge of your finances if you are still here, but you just are not able to manage your finances yourself? And of course, you change your mind. So, no, I can't make the decision for them, but I can certainly help guide them and think about some of the things that they're not necessarily thinking of, at the front of their mind.
Sometimes the person that might come to mind to be the right successor trustee really isn't. I think, for example, I think the classic case is, you have one son who or daughter who's particularly successful, and the idea being, well, they really handle a lot of money and they do these, all these things, and yet they might be distracted, not give attention, or more importantly, not communicate with the other family members as well. On the flip side, they can delegate and hire professionals. So what's a common problems on deciding who the successor trustee should be, and what are common solutions you advise?
I mean, the biggest problem is clients want to name all their kids as the trustees together. And now we have 3 kids, 3 opinions, right? You're muted. I can't hear you.
I was going to say, what could possibly go wrong with that?
Right. These are also the same kids that are not going to fight about the money,
Right, right.
And I have to have the conversation with them about that too. I understand why because they want to be fair. That's usually what they say when I ask why. We want to be fair. We don't want to pick one over the other. But the reality is, having all of them means more of a recipe for disaster because everyone has an opinion, right? Again, can't make the decision for them, but I really, really don't like to see multiple trustees, especially if we have an even number. But one of the things that they can certainly do, if you want to name one child, maybe name a co-trustee that is not one of your children. That can sometimes help buffer the fact that the other two or the other child hasn't been selected. That kind of helps. And then there are actually mechanisms that we can build into the trust where the beneficiaries who are adults and competent can actually remove a trustee, and you can build in mechanisms for, okay, if a trustee is removed, how do we appoint them and who the successor trustees can be. You can say successor trustees have to be non-related. You can say they have to be maybe attorneys. I mean, of course, certain choices are going to cost more, but these are the kinds of conversations I have with clients that we talk about, okay, if we ever have a situation where a trustee is removed for whatever reason, what are the parameters you want to put in place for appointing that successor? Because we want this trust to continue, and we want to avoid having to go to court where the judge has to make a decision, because of course that's going to cost money and take time.
So I know you through real estate. Along the way, you've done some real estate business. We were colleagues for a period of time, and that's mostly my interest. I get involved with trusts are put together, but the property isn't put in the trust. Kind of like buying a safe deposit, a safe box, and stacking your gold and precious metals on top of the safe instead of putting it in the safe and locking it. In California, we do have a mechanism that can possibly put it back in, though it's very cumbersome and expensive. It's not as easy as it sounds. And I don't think in Florida you have that type of mechanism. So talk about when people do an estate plan, how important it is at that time to review the funding options and get that work done at that time.
Okay, so funding. Funding is just as important as creating a trust. So you have to think of a trust as a box. When you pass away, whatever is in that box is going to avoid probate. But if you don't put anything in the box, you haven't funded your trust. Now, I know what you're talking about. I don't know what it's called, but I've heard of it. That kind of helps you get things in the trust after someone passes away.
We call it Hegstead petition in California.
Hegstead. We don't have those in Florida. So what we're stuck with is your pour over will. So a lot of times when I'm talking to my clients, we're doing our consultation and I tell them the package includes a pour over will. They want to know, why do we have a will if I'm creating a trust? The whole purpose is not to have a probate situation. But the reality is, a lot of people either forget about property that they owned, or they just never get around to completely funding. Or you create your trust, you put whatever you have in your whatever property you own at that time into your trust, and then life happens, you acquire more property, and you just never put that property in the trust. So what a pour over will does is it kind of takes care of what you forgot. And it also takes care of what you may have inherited or just didn't even know existed, because that happens as well. And it pours it over from your probate estate into your trust. So all of the rules and parameters you created on that pretty trust now are going to apply to that property that didn't get in your trust before you passed away. Of course, now this does mean we're going through probate. which means whatever those assets are, they're going to be subject to your creditors. So we want to avoid that as much as possible by making sure you, step one, create your trust, and step two, fund your trust, because that's just as important as having the trust.
So again, I know you can't give us legal advice, but from a business point of view and just general rules, it's so funny because my wife and I had a trust done years ago, and it's still mostly appropriate, though we probably are overdue for an update. But anyhow, we have a trust, and I'm in business of real estate. I'm buying an investment property that we're closing escrow in about a little less than 2 months. And so I'm buying it. I formed an LLC, and I realized, yeah, but who owns the LLC? Me. Well, that's wrong. It should be my trust. Because if the ownership is me personally, God forbid something happens to me, those shares go to probate, or the value goes to probate, versus going into the trust. Talk a little bit about Florida. How would you set up, if you have real estate investors as clients, do you recommend LLCs, and should they have the LLC ownership held by them individually or by trust, or does it not matter?
So a lot of that is going to be client specific. I do recommend, if you have real estate and it's investment property, every property should have its own owner, right? Whether it's going to be an LLC or an INC or what have you, that's a whole other conversation. And again, it's very specific to the individual client. With LLCs, as far as who your owners are going to be, we want to think about things like creditor protection, asset protection. In Florida, if it's a single member LLC, what I will tell you is there's not going to be any creditor protection. So if it's just you, it's your LLC and you are the only member of that LLC, you're not protected if there's a slip and fall. They're coming after you and whatever assets you have. So you want to think about that. Maybe add someone else as a 1% member. There are certain things you can do. Adding your trust can be the member. But again, if it's just one member, guess what? So multiple members, I love real estate. I think it's the key to generational wealth. And so all of my properties personally are owned by its LLCs, and it's always two members, myself and my husband, we're each a member. So we have that double protection. And then what you also want to do is, because you mentioned, okay, what about the probate aspect of having that ownership interest, that member interest? You're going to put things in either your trust. You can assign your LLC interest into the trust. That's one way. But then remember, we have our governing documents. We have our bylaws if it's an INC. In these documents, you can actually have trust avoidance language. So what happens to this person's, probate avoidance language. So what happens to this person's LLC membership interest if they pass, or when they pass away? You want to transfer it somewhere, and you want to have that question answered, because that's how we avoid probate. If there's no answer and that person just dies with it, yes, you're back in probate. So it's all about, in that instance, you want to make sure you have business succession planning included in your estate planning.
Man, it gets complicated buying a house, huh?
It does. I mean, if it's your homestead, it's not that complicated, right?
Correct.
Once you're adding these investment properties, you have to think about probate as well as asset protection, because with properties comes liability, and you want to try and insulate all of your other assets from liability from property A and property B. If someone has a slip and fall on A, you don't want property B to be involved in property A's issues.
And you also have tax issues to think about too, which is another aspect of this. So that's why you want to talk to professionals and not do it on your own. I said as I'm doing it on my own. No, I've been instructed what to do.
The irony.
No, I have an attorney, I have a tax accountant who told me what to do. I'm following their instructions, but they give me those. I should probably update those, that input with them and get together with them. Okay, so one of the aspects that I think to attorneys feel, I don't mean to put it down your industry, but I think can feel trivial, that I think is ultimately really important to the customer, is the administrative piece, which is really like, who has the papers, where are the papers, and how are they handled? Mm-hmm. And I say this as a real estate agent. I don't know if you had this experience where you ask customers, how do you hold title of the property? And they pull out this beautiful binder, and it's like a notebook and a binder. And so it looks like it has fake leather, and it has a printing on it, and all these tabs and documents. But you notice that none of the signature pages are signed, and or they're the grant deed for that property that the attorney dutifully prepared right there, never signed, never recorded. And so we have a whole industry around those problems. And so I normally advise customers, not from legal advice, but from a business advice. If you're choosing attorneys, you want to give more value to the one that will follow up on the funding, and that means the actual documents and the follow-up to make sure it gets in the trust. And then you also, I think, want to have an attorney who has a process that includes them having a copy and you having a copy. That way, if you inevitably lose yours or pass, there's a solution. Now, I'm not saying that's the right way to go, but how do you address the issue both of the follow-up and the funding of the trust from a paper point of view, and then the storage of the documents?
So at the end of the signing ceremony for me, my clients leave with the original documents. If they come to my office, because I do
The original executed documents.
yes,
And notarized.
are going with
Or
them. I
whatever.
do not hold on to originals because how long are you holding on to them? It's a mess. I don't do that. But I also, if they are physically in my office and they do their signing here, I will actually keep a copy. I make a copy for myself. I will also share an electronic copy with them through my portal. So they're going to have the electronic copy. They're going to have the original signed documents with them when they leave. For any deeds that are prepared by me. So if it's a Florida property, if they have Florida real estate, wherever the real estate is located in the state of Florida, I will actually handle the recording because we prepare those deeds as a part of their package, as a part of their plan, and I handle the recording. So
And why
again,
not? Why do I understand? Nowadays that you can do it online,
exactly,
you can do
exactly.
the notary online and you can do the recording online. In California, for example, why would you not do that for your customer? It costs like nothing. You have a paralegal, you can charge an extra $100 their time or $50 their time, but it's done. Why not?
Yeah. And so,
I'm sorry.
especially if it's okay. And so, if it's an in-person signing here, I actually send it for recording before my client even leaves the office because I let
Beautiful.
them take the original deed with them in their package.
Beautiful.
And, some counties, I have one county, my county, St. Lucie County, they will actually record that deed same day. If I send it maybe at 10, 11 o'clock in the morning, I'll have that recorded deed that afternoon. And I email that to my client and I also will mail it because some people still like to feel the paper.
Yeah.
And I mail it to them. Now, if you are not here, because again, I do cover the whole state. So if you don't do a signing here, and I'm working on changing the process, but right now I give my client, they have complete flexibility on how they get the copies to me. Some of them just go to a FedEx and they make a whole copy of everything and they put it in an envelope and they send everything to me and I scan it. I have no problem with that. They do have to send me any deeds. I need the originals because in order to record it, I have to have the original in my hand, even though I'm electronically going to record it. That's just the requirement. I have to certify this is an original. And so they have to send it to me and I will return it to them with that copy of the recorded. Some clients, they want to upload it into the portal directly, and I'm perfectly fine with that. It takes a little bit more time, I think, for them to upload, but whatever, it's completely up to their convenience. Now, I have some notaries because they work with remote notaries if they're, local, if they're doing their signing elsewhere. Some of the notaries will also handle the copying for them. That's an added service, of course, but that's, at the end of the day, when the clients, especially if they mail that hard copy to me, I still upload it to my portal and I still share an electronic copy for them because I think it's very important that they have an electronic copy as well as the original sitting in front of them.
I like all that. Very complete. Thank you for sharing all that. So let's talk about the business side a little bit. You're an attorney, and one thing I've noticed is that there's a misunderstanding. Some people think that, well, the great attorneys just sit around and business walks into them. In my experience, the most prolific attorneys have a certain amount of time structured. They do business development. It might be higher level business development. They might be particularly good at it, but they're doing something that generates business on a regular basis. So talk a little bit about, you've had some real social media success. Talk a little bit about your business development. What do you do and kind of what are you working on going forward?
Okay. Whew. So yeah, social media is really, really a big part of my practice. It wasn't always like that, but when I initially opened in 2020, everyone said you have to be on social media. You have to have a presence. And so I would post videos and I didn't really see much results other than people that knew me. It kind of kept me top of mind for them, but that was pretty much it. It was great for me for practice because I am an introvert. And so getting in front of cameras, I was not comfortable with it. And so I did develop comfort with it just by posting those videos. But consistency with social media is the key. And so I really, really focused on at least being consistent with my posts. And eventually it worked out because randomly I had one post that went viral, and it was a simple post. It was an older post also. So, it's not, hey, I posted it today, it went viral tomorrow. This was a post that had been up for, I think, about 4 to 5 months. And all of a sudden, randomly, it just started being shared and saved and liked. And it was basically, why I said that a will without probate is just a piece of paper, because the will is your instruction manual for your probate. That was really all that post was. And then that was October of 2022. And then I would say a year later, because it was actually a post that happened to be put up on September 11th. I only remember the date just because it's the date, right? That one went viral as well. So basically, a year later, I don't even remember what that post was about, but that one went viral as well. And so as a result, on Instagram, I have 100 and I think 4,000 followers.
Wow.
And I had to completely change my intake process because I was getting inundated with phone calls and people from all states. And
Right.
so now the intake form on my website will ask you, are you a Florida resident? Are we talking about Florida probate? If not, just tell me what state and what city the case is, related to, because I'd be happy to refer you. And I just provide, the contact information. If I have one attorney in that area, then that's it. But if I have multiple, I'll give them all three or all four so that they can, reach out to those attorneys and work with whoever they're most comfortable with. So that's where my social media kind of started. And then I also operate a Facebook group that's titled Probate and Estate Planning 101. And that has kind of built itself organically, and it's got about 4,600 members at this point. And in that group, it's really, it's still a newer group, because when I first created it, it was kind of set it and forget it. And so now I'm trying to really create a focus in that group. And I have also, I'm going to be allowing attorneys to join, because I've gone back and forth on whether attorneys are going to be in there, because it is a marketing tool for me. But what I am doing is it's actually, the link is in there now for attorneys. When I add them to the group, which I will start to do, they will be able to schedule a meeting with me, fill out a quick little intake form. We are going to have a one-on-one so that I can vet them, and then we can create a referral relationship. And I can also add them as, a referral partner. So those are my social media. And then, of course, Google advertising. And at the end of the day, even though it's 2025 and we want to say tech is great, you still need those in-person meetings, those networking meetings, building your in-person network. For me, realtors are a good source of networking and referrals for me, as well as people that are in the financial planning space and people that are in insurance. Those are my key referral partners.
And so, when you say live events, what type of live events would you see realtors at, for example?
I mean, you see realtors everywhere. For example, I went to last week, we have a landlords association meeting, and it's just my city, and it's at Elks Lodge. And, it was started because it was focused on landlord ordinances at one point when they initially created it. And so it's very real estate focused. And so naturally, you're going to have people that are in the insurance, so property insurance space come there, and real estate agents are also going to go there. Being an affiliate because I do have a real estate license. And so having an affiliate with the local board allows you to go to some of their meetings. They have something every Thursday called Marketing Madness, where the agents are there, and it's a great opportunity for me to just meet with agents and let them know who I am and what I do. Because a lot of times they have situations where they have a listing, and guess what? We need probate, or they have a potential listing. And when they look up the property appraiser's website, they see those key letters EST, which means we need probate because the owner is not here, right? And so just being there and letting them know that I exist and this is what I offer service-wise, that's pretty much, what you have to do. You have to constantly be out there and let them know that you're local and this is what we do.
So you're also, as you mentioned, have been a real estate agent, and you work with real estate agents. So give some advice to a real estate agent who wants to be more active and sees this as an area where they can learn and be of value to their customers. What activities would you recommend a real estate agent to do to build their business?
So first and foremost, if they're going to be in the probate space, they need to actually understand probate in their state.
Oh, imagine that. Actually know the
Right.
product.
And
Wow,
that's
you're so hard. You're so difficult. Why would
my
they?
biggest pet peeve is, when an agent sells themselves to their client as
Yeah.
someone who is knowledgeable of probate, and then, they get the listing, and now they reach out to me, and I can tell from the agent's questions or from the way they're operating that they don't know the first thing about probate. And there are resources out there that you can tap into. So before you reach out to an attorney, especially, and ask us to refer things to you, please make sure you actually understand probate. Because if my first interaction with you is seeing that you really don't know it, I'm definitely not going to refer things to you again. I will tell
Right.
you that. And same thing, you're not providing your client with a service if you don't know the topic, right? If you're telling them this is something you offer and this is something you are skilled at, you need to be honest and you need to really be knowledgeable of that subject. So definitely get yourself educated. That is probably more important than anything else, because your reputation matters, right? And then, of course, as far as the number one question, how do I get you? How do I, become a referral partner for me, the attorney? I am actually, one of the things I'm going to be doing this year is creating a course specifically for real estate professionals that is guided to probate. It's going to be Probate for Realtors 101, something along those lines. But reaching out to me, and I'm probably not the best person because I do have a real estate license. And so it does, sometimes they don't want to reach out to me because they're afraid I'm going to steal their client, which I won't. But I understand that hesitance. But, if you are at events and you see that attorney, you want to build a relationship with them and make it organic. Don't turn it into, don't make it obvious. Don't make it just about the business.
Hmm.
Really care about that person as an individual and build a relationship with them as a human being before you focus on the business.
Hold
Um,
on, hold on. Attorneys are human beings too?
yes, we're
What?
people.
What? What?
Cold calling is not the best way to do it. I'm
Hmm.
going to be honest. I do get those mailers. I don't even open them. I open it to see
Hmm.
what it is, and then it goes right in the trash.
Yeah.
So save your money. Don't send attorneys the mailers. If I don't know you, the odds of me actually, sending you business, or we've got a lot going on, right?
Yeah.
But you see me on social media because I am there, and people have they'll come into my DMs, and I will send you my link. I actually have a link just for us to have a virtual meeting so we can talk about who you are, what you do. That's really the best way to connect with me, is through the
Hmm.
DMs and social media or emails. I've also received emails from real estate professionals who are just interested in finding out more about how they can work with me. But let me know who you are and what's the value in me working with you, because you want to stand out. So if you have a social media page where you're showing your value, include that link so that I can see it, because I'm going to click, I'm going to look, I'm going to see who you are. I'm going to vet you before I even, have our meeting.
It's not
Because
hard anymore. You can do it in 30 seconds, right?
I know, but you gotta vet. I have to vet people,
Yeah.
and you want to make sure that you stand out when you do reach out to me.
Well, look, Alecia, obviously we can go on. We've went on about probate for a while. We've gone about estate planning. We can go on
Mhm.
about real estate, I'm sure, as well, for quite a while. You have a lot going on. You have a Facebook group, and that's Estate Planning and Probate 101. In Facebook, you have your other social media. For somebody who wants to get in touch with you more, your website is genesislawpa.com. That stands for what? Professional
Professional association, yes.
Association, such a format. So again, for more information from Alecia there. Really appreciate your time today, as always, and you've been very generous in the past. Thank you so much for your time and continued success. Look forward to talking to you.
Thank you so much.
And for the rest of you, this is Estate Planning Weekly. We get together every week with an interview leading professionals in the space, most commonly attorneys, but we also do with other wealth management professionals and other vendors that support our clients along the way. If you like this, please like it. If you have suggestions for other topics or interviewers, please put it in there as well. If I can help, please reach out directly. I'm Bill Gross at Bill Gross Probate on social media. And as always, make today your best day ever. Thanks so much.